Welcome everybody to today's webinar on SMSFs acquiring assets from a related party. So for those of you that attended last month's webinar where we talked about in-house asset rules, I deliberately did that in regards to introducing the concepts of in-house assets because understanding and appreciating the rules around in-house assets makes it then easier to transition into the conversation around acquiring assets from a related party, because the two areas are directly linked with reference to the type of assets that we can acquire from a related party. So it's good to kind of get that in-house asset definition out of the way first, so we can then jump into talking about what we can and can't acquire. Of course, standard disclaimer applies. As I often talk about with these related party and investment restriction type sessions that I do, is these rules haven't really changed to any great extent over the let's sort of go over the time frame of self-managed superannuation funds. But what's happened in that time period, that 20 odd years, 25 years, is that we've seen situations where obviously investments change, the type of investment opportunities, certain other opportunities arise, and so then we have to investigate to determine whether or not they fit the criteria of the existing investment restrictions. And so it's always good to have a bit of a refresher around these sorts of rules, just to appreciate sort of where the world sits when it comes to self-managed super funds and acquiring assets from related party, primarily because we are talking about closely held structures, being the self-managed fund where the trustees and the members are the same people in the majority of the events, and in many fund situations there is a desire to look at the concept of whether you can move assets from outside of the super environment inside the super environment. So what I also do regularly when I talk about investment restrictions is I highlight the position from an ATO point of view. So the statistics around um, various breaches around various investment restrictions. And we notice that related party acquisitions it represents a very low percentage of breaches, and in fact is the lowest of all of the breaches from a percentage of breaches, but it's also very low in the percentage of the value of breaches as well. So it's not that related party acquisitions tend to be a problem from a compliance point of view for self-managed super funds. Certainly takes up a lot of questions and question space in this area, but it's also linked intrinsically to a number of other key issues around the various investment restrictions. And for me, probably there is no greater link to the related party acquisition rules than the sole purpose test. And it's one of those areas that we talk about the sole purpose test. People like myself talk about the sole purpose test sort of fairly nonchalantly in concept of, the purpose of super is to satisfy the core purpose, or a core purpose and an ancillary purposes, which is the provision of retirement benefits. And I'll run through those core purposes in a moment. But the key to the sole purpose test is that it's ultimately the singular most important test to determine eligibility for our tax concessions. So we must satisfy the sole purpose test at all times. So it's not just a test about paying benefits at the time that's appropriate, i.e. retirement, turning 65, etc., death of a member, but it's about the decision-making processes along the way of the fund, ensuring that the reason that the fund exists, the reason that the fund transacts, is that ultimate payment of benefits and maximizing the benefits that we can pay out to the members or their beneficiaries in the event that they satisfy the other condition of release requirements. So, given that the objective of all self-managed funds and all superannuation funds is the provision of retirement benefits, right, for individuals, or the provision of benefits when they reach 65. So let's classify those two as our desirable sole purpose test requirements. We have to make sure that if our objective is to pay a pension, if our objective is to pay lump sums, whatever our objective is for the fund's purpose, that we are investing and undertaking transactions that's sole purpose is to provide for these benefits, right? We've of course got, in addition to that, our ancillary benefits, so termination of employment, ill health, sort of temporary permanent incapacity, and then death benefits beyond retirement, beyond age 65. And this is one of those areas that, again, you'll hear me talk about quite regularly, is that superannuation has been droned into us or drummed into us by the government over many years, that the purpose of super is not an estate planning vehicle, but by its very nature of the sole purpose test, it is. It's just to what degree, and the core purposes dictate that we are planning for the undesirable event of the member passing away before they retire or before they hit 65, and then that becomes a core purpose. But then post retirement, post age 65, it's an ancillary purpose. So the objective is to pay benefits when the members retire, pay benefits as the member turns 65. Ancillary to that is that we pay a death benefit to the beneficiaries post those events occurring. So that's not what we're setting the fund up for, but it is one of the reasons that it is available and satisfies the sole purpose test. So we're meeting this requirement, and that's a fairly broad statement that the purpose of the fund is to provide for the retirement benefits. But then when we're transacting, we're doing so in a way that is not providing us with any other benefits that aren't in alignment with those core and ancillary purposes. Now, what we've had historically is references from the regulator, so from the tax office, and through this ruling, SMSFR 2008-2, that provides us with some guidance around the key elements that determine that a fund will be satisfying the sole purpose test. And so when we're looking at this, what we're really trying to identify is there some form of benefit that the members, that the beneficiaries are obtaining through the actions of the fund, right, or the action of the trustees or whatever, are resulting in benefits being provided to the members' beneficiaries that aren't in alignment with the core and ancillary purposes, and then to what effect, is that benefit sort of pushing the boundaries of what is acceptable and what's not acceptable. So the easiest term that we reference there is there some form of current day benefit you're getting, right, as a member or a beneficiary from the transactions of the fund, and how significant is that benefit, and what led to that benefit. And so when we go through the concept, we talk about the benefits, an inherent or unavoidable part of other activities undertaken by the trustees that are consistent with the provision of the benefits specified by the sole purpose test. Right, so inherent, unavoidable, the benefit is remote or isolated or is insignificant, whether it is provided once only or considered cumulative with other like benefits when assessed relative to other activities undertaken by the trustees that are consistent with the provision of benefits specified by the sole purpose test. So this is where you get a situation where you link those first two with the bottom one there. All of the SMSF's investments and activities are undertaken as part of or are consistent with a properly considered and formulated investment strategy. So I guess what we're pointing out there through these key elements that determine things to be okay from a sole purpose test point of view, if there is a benefit associated with it. And if you look historically, it's like, did the fund undertake an investment, and they undertook the investment having researched that investment? It's incorporated within the investment strategy, so it fits within whatever the parameters of the strategy are. And by undertaking that investment, there is actually some form of benefit that is provided to the member or to the relatives. However, that benefit is insignificant, right? From a valuation point of view, or it's unavoidable. And the example that I use often, and it's now a really old example, I probably need to find a newer one, is the old Coles-Myers cards, right? So when self-managed super funds were evolving in the early 2000s, a lot of self-managed funds invested in Coles-Myers. They got with their Coles-Myers investment, they got a discount card. They got a discount shopping card where they'd get a 5% discount. But then, as Coles Myer would pay dividends, all the dividends would be payable to the superannuation fund. And so the tax office identified, they said, well, it's an unavoidable part of the activity. If you invest in Coles Myer, you get a shareholder's card that provides you with discounts, right? And ultimately they said that the benefit is insignificant. But then when we turn over and we look at the factors that will determine that the fund is not satisfying the sole purpose test, the trustee negotiated for or sought out the benefit, even if the additional benefit is negotiated for or sought out in the course of undertaking other activities consistent with the sole purpose test. The benefit has influenced the decision making of the trustees to favour one course of action over another. Benefits provided by the SMSF to the member or another party at a cost or financial detriment to the SMSF. Then it talks about patterns of investing as well. But that final point there, if we go back to Coles Myer, what Coles Myer did at the time was they changed their rules around the shareholders card, the discount card. And they said they went from a position where everybody got the discount card, right, and everybody got the dividend to you can choose between the dividend or the discount card. And so from a regulatory point of view, the tax office came out very early on once Coles Myer had made the decision and said, you can't choose if you're a self-managed super fund trustee, right? So you have to take the dividend, because if you are taking the discount over the dividend, then that is financially detrimental to the superannuation fund. The decision to take that has influenced your decision. The decision to invest in Coles Myer to get discount has influenced your decision to do it through the superannuation fund. And so they said you don't have a choice. And so when we're looking at our related party acquisitions, we have to go, why are we actually undertaking this transaction? And it's quite a for me, it's quite a fascinating area, because to me there's some form of logical argument, right or wrong, that suggests that from a sole purpose test point of view, that any decision to acquire assets from a related party from the fund, and taking out of the situation here contributions, because we can contribute shares, right, and we can do all of the things that we're about to talk about from an acquisition point of view. We can either do it as a purchase or as an acquisition. So if we're doing it as a purchase or as a contribution, if we're doing it as a contribution, then we're increasing the capital of the fund. If we're doing it as a purchase, then effectively there's an exchange. There's an exchange of cash for those shares. And so the tax office are ultimately able to look at that to say, well, how has that transaction benefited the superannuation fund? Are those investments in line with a long-term strategy to provide for retirement benefits? So we're going to park that. We're going to park that piece and come back and visit that a little bit later. But ultimately, when we are making decisions about the related party acquisitions, we have to work out whether or not that is in the benefit of the superannuation fund or not. And so when we start to look through what our related party acquisition rules are, we come into pretty much our stock standard SIS approach to everything, which is, and I'm saying this relatively lightly here, but in the SIS environment, everything is prohibited until it is accepted, right? So until there is an exception to the prohibition, most things are prohibited. And so when we look at the related party rules, right, it says the trustees or the investment manager of a regulated super fund must not intentionally acquire an asset from a related party of the fund, right? So paraphrase, trustees are prohibited from buying assets from related parties. That's what section 66(1) says. Of course, then it's subject to certain exceptions to the prohibition. So we go, okay, well, you're not allowed to do this, right? However, in some circumstances you can. And we then need to have clarity as to what those circumstances are to allow that transaction to be acceptable. And ultimately, the rules are quite simple, right? The acquisition rules are quite simple. The stuffing, the meat on the bone, the elements of the actual investments can become quite complex, right? When we're looking at some of the exceptions, but in large, the exceptions are pretty simple to understand. And that is, we're prohibited from intentionally acquiring certain assets, except listed securities. So these are shares, units, or bonds listed on an approved stock exchange. And that list, right, the approved stock exchange, is fairly significant. Okay, there is a long list. So largely all of your stock exchanges from Australia, the vast majority of international stock exchanges that exist are on that list. So I mean, self-managed super funds can buy quite a significant number of shares from related parties if they're listed. Key, they must be undertaken at market value. And we'll talk a little bit about the arm's length side of things as we go through the presentation as well. And then for funds with no more than 6 members, right? So your classic self-managed superannuation fund, your small APRA funds there, business real property. So land and buildings used wholly and exclusively in a business. So there are two biggest acquisition opportunities, is listed securities and business real property. So as I said before, listed securities, pretty simple to define, right? Know your stock exchange, know your list of stock exchanges that you're able to acquire from. As long as you're acquiring at market value, you've got no problems with that transaction. Business real property, having an understanding of what business real property is, right, is again a key issue to determine whether or not we can acquire an investment. So we then need to understand what business real property is for this transaction. And our section 66 gives us our definition. So it's any freehold or leasehold interest of the entity in real property, or any interest in Crown land other than a leasehold interest, being an interest that's capable of assignment or transfer, or if another class of interest in relation to real property is prescribed by the regulations for the purposes of this paragraph, then any interest belonging to that class that is held by the entity. So for most self-managed superannuation funds, we're ultimately looking at paragraph A, right? And that's, we can do a business real property presentation and webinar to look at things like, the broader extension of business real property. And that in itself is a significant session to do, because it's got its own ruling. It's got its own SMSF ruling from the ATO's point of view, and there's been a lot of evolution in that space. But what we're ultimately looking for is property that is used wholly and exclusively in one or more businesses, whether carried on by the entity or not, right, but does not include an interest held in the capacity of beneficiary as trust of a trust estate. So we're looking for property that is used wholly for business. So that means to all levels which the property can be used, it is being used for business purposes, and exclusively. So wholly and exclusively are two separate words. They're not interchangeable words, right? And the ruling on business real property does go into this to some extent as well. But we're saying to the level which the land, the property or whatever is being used, it's wholly used for business and exclusively. So when we talk about exclusively, we're saying, okay, well, if you've got business premises, right? So if you've got a factory or whatever, or if you've got, let's say, and the classic is, say, your accounting firms, your law firms, your medical, all those, anything that has been built inside what was once a residential property can be business real property if it is used exclusively for business purposes. So if you have an accounting practice, financial services practice that operates out of what was once a house, but it is now used exclusively for the business, then it's business real property. If it's proportionately used, part for the business and part for living in, then you're not going to satisfy that business real property exclusion. There is, of course, the exception to that, which is primary production land. And again, as I said, that goes well beyond the scope of today's webinar, but it might be something that we start to look at in the 2026 webinar run that we do. So having an appreciation for what is business real property, that's the difficult part of the acquisition rules, is getting it clear. And it's business real property at the time of acquisition, right? So we have to look at acquisition separately to our ongoing investment piece. But our ongoing investment piece, we have our in-house asset rules to cover whether the property is business real property or not. So at the time of the acquisition, does the asset satisfy the definition of business real property? Right? And if it does, then you can acquire it from a related party. If it may, or if it's likely to satisfy the definition, that's not good enough. It's got to be business real property at that time of acquisition. for you to be able to bring it into the super environment. We then have our further exceptions, and these are our in-house assets, and I'll break down which assets are included in that in a moment, but our certain in-house assets, so we need to have that clarity as what in-house assets are. And then we got the additional exception that was introduced well after the rest of the exceptions, which is the breakdown of relationships. So the ability where we have a relationship breakdown to move assets from one fund to another. So it really allows for ease of transfer in specie transfers, for example, where a member, there's a family law break between the members of the fund, and we're splitting assets. Instead of transferring cash, we're going to split assets. Then we've got this effective overlaying exception that allows us to transfer assets from one self-managed super fund to another, albeit that they're both related parties at the time. So it gives us that opportunity to do that actual transfer. So they're our primary exceptions. We've got listed securities, excuse me, business real property, in-house assets, and then a general exception for relationship breakdowns. So what we then have to have comfort in is what is an in-house asset. And again, this is what we spoke far more depth in our previous webinar. So you can always go back onto the SuperGuardian website and view that webinar for more detail with regards to the in-house asset rules. But in summary, a loan to a related party of the fund, an investment in a related party of the fund, an investment in a related trust of the fund, and an asset subject to a lease or a lease arrangement between the trustees of the fund and a related party. That's our definition of in-house asset. We then have to go ahead and look at the exception rules under 66 2A with regards to what we are able to acquire that is an in-house asset. And there is one specific exclusion here, and that is the asset subject to a lease or lease arrangement between the trustees of an SMSF and related party of the fund. Now, again, very quick history or historical commentary on that is that before these rules sort of came in 2010, before we had clarity with this ruling around the acquisition of assets from related parties, and before we had rules around collectible and personal use assets, which were introduced in 2011 and then took full effect from 2016, was if you had something like a piece of art inside a self-managed superannuation fund, and that art was hung on the wall of the business premises or something like that, then that would be an asset subject to a lease to a related party, right? And so that would meet the definition of an in-house asset under the old rules. But what that also kind of meant before this ruling took full effect was under 66 2A exception, a lot of people tried to look at it and say, well, okay, well, if we take this artwork that is subject to a lease and we transfer it into the fund and have it subject to a lease, then it's going to be acceptable under the in-house asset acquisition rules. And the regulator in that final ruling said that is not what the legislation's about. It's not about the opportunity to transfer all of your assets that you hold outside of super into super just by means of creating a lease arrangement or putting a lease arrangement in place and saying, well, this is an asset subject to a lease, so therefore we can transfer it in. So that sort of kiboshed the whole loosely collectible and personal use asset transfer requirements. So definitely no capacity to do that there. And of course, then the collectible and personal use asset rules kicked in from 2011, as I said, which definitely stopped any capacity to do that. But what it means is that some of our investments like widely held trusts, which might be our managed funds or whatever that are not listed as such, can be captured from an acquisition point of view under the in-house asset exception. And similarly, a Division 13.3A investment, so our 1322C unit trust and 1322C companies, can be acquired under this exception from a related party. So if we're holding business real property or other properties through a trust vehicle, and it meets all of the requirements of 1322C. So, there's no borrowings, there's no other investments in the trust, all those other key things that we addressed in the previous webinar, then we can acquire those investments from a related party of the fund. So that's fairly significant in giving us the capacity, and it's where I kind of I address this issue, and I address it through different presentations that I do. But if you've got someone that looks and say, well, we want to transfer property into the superannuation fund, but we don't want to entertain or engage in limited recourse borrowing arrangements, for example. Well, it makes it a fairly clunky process to try and transfer property piece by piece. So to do a land title transfer over a certain percentage, then do another land title transfer over another certain percentage, and do that with business real property over a period of time. If property is unitized through the use of a unit trust, then you've got this one vehicle, the unit trust, holding the property, and the ownership of that property will remain the same. And then the SMSF potentially acquiring the units bit by bit over a period of time. So in a way, it sort of provides liquidity over that otherwise illiquid style asset, and liquidity in by virtue of the unit. So, the rules are quite accommodating there for us to be able to transfer even certain lumpy assets in over a period of time if we don't want to go down the borrowing path inside the SMSF environment. So there's some key things for us to contemplate from that acquisition piece. Related party, what is a related party? Now, again, this is an area that I did spend some time on last month and have, regurgitated this stuff a lot of times. So I won't drill too deep in regards to who is a related party, other than more of a refresher piece of commentary as part of today. But our key one is fund members. So again, what we're addressing here is a couple of things, right? So we're addressing who is a related party from an acquisition point of view, right? And then who is a related party for the investment side to determine whether or not we can actually acquire that particular investment. So when we're making the initial acquisition to start with, the first question we always ask, and I'll put this in the summary at the end as well, first question we should always ask when transacting from an SMSF, who are we acquiring the assets from, right? Because that's going to dictate whether we care about Section 66 or not, right? If it's unrelated, then we don't have to worry about all these exceptions and anything else. But if it is a related party, then it's important for us to then go through the process of saying, who are we acquiring from? Right? So as trustees of the fund, who are we acquiring from? Then what are we acquiring? And then what is the market value, right? So they're the kind of the three questions that we need to address, but it all starts with the who, right? Once we know the who, we can determine whether or not they're a related party. If they're a fund member, and they're the simplest scenarios that we've got is, and this is, the way that the legislation is written here, the trustees must not intentionally acquire an asset from a related party, right? Well, very difficult under any sort of argument to suggest the trustees engaging in any transaction with themselves is not an intentional acquisition from a related party. So generally the broad family sense, that intention piece is out the door, in the sense that it's always intentional, right? When you're dealing with related parties or fund members and the family members of those fund members, it's always going to be an intentional transaction. You cannot inadvertently acquire something from a related party, right, without intention there, right? It's like, I did not know that I was buying that from myself, right? That's not going to wash with anybody. So we have to have clarity there. We've then got our standard employer sponsor of the fund. As I've said many times in this space, it is such a small percentage / minority, whatever you want to call it, within the SMSF space, that standard employer sponsors still exist. So then we're looking at related parties, meaning fund members and our Part 8 associates of our fund members as well. So that then brings us to that standard diagram that I will always raise here, which is we've got our self-managed super fund, we have our members, we have the relatives of our members, we then have any partnerships, so any tax partnerships that those members are in, right? And then any partners within the partnership is also a related party of the member of the fund. and the spouse and children of the partners in the partnership become related parties of the fund. So, in certain investment situations, there may be this is where intention can potentially become an issue. Is you might not have drilled down to know that you're dealing with the child of a partner in a partnership if there's multiple partners in that partnership and you don't have a relationship. However, again, even by raising it as a comment in the presentation, how often does that actually occur in the SMSF space? Probably never has. And so our main focus and my main focus from an education point of view is really drilling into that. If you're going to bring assets in that you own outside of super, right, which is most of the time the transaction that we're looking at, understand how the rules work. And then, of course, in addition to all of those people, we have our related companies and our related trusts that we need to ensure that we have that control piece over. Again, our relatives for related party transactions come down to our relatives under the definitions of the SIS Act. So we've got our grandparents, parents, siblings, spouse, lineal descendants, um, uncle, aunt, niece, nephew, adopted child, and our relatives' spouses. So, what we don't include there is our former spouse. What we don't include there is our cousins from an investment point of view, from an acquisition point of view. So, that's the broadness of what we're looking at from a transaction piece when we're identifying who the relatives are, and then from a control point of view, this is where we have our majority voting interest piece, where we control the casting of more than 50% of the maximum number of votes that might be cast at a general meeting of the company. And if we don't have that majority voting interest, then we have to turn around and look at sufficient influence. So if the company or a majority of its directors is accustomed or under an obligation, formal or informal, or might reasonably be expected to act in accordance with the directions, instructions, or wishes of the entity or entities, whether those directions, instructions, or wishes are or might reasonably be expected to be communicated directly through interposed companies, partnerships, or trusts. Basically, how much power do you and your big list of collective groups of related parties, how much influence do you have over the company or trust? So not shareholding, but influence. And if you have that influence, then it is going to be a related party, a related trust. And then again, beyond sufficient influence from a related trust point of view, the trust that a member and its associates, so its broad group, controls, which is a fixed entitlement to more than 50% of the capital or income, sufficient influence, plus the ability to remove or appoint the trustee or a majority of the trustees. So often what we'll see here, and this is where we look at the decisions around acquiring assets from a related trust, is, do you and the family have, or do the members and their family have between them that more than the 50% of the capital income? Do they have the ability to remove or appoint the trustee? If the answer is no, then you've got an unrelated trust, and then you can't acquire units in an unrelated trust from yourself unless it meets the definition of 1322C or a widely held trust. So then, so you've got to do the whole related party piece first to identify whether or not it's gonna fit there. If not there, does it fit under 1322C? If not there, does it fit under the widely held trust definition? And so when we're looking at unlisted investments, there are a number of steps that we have to go through to make sure that we're doing the right thing from an acquisition point of view. So as I highlighted before, and have talked through the presentation, I've mentioned SMSFR 2010 one. So this was our ruling, which obviously came out finally in 2010, which dealt with the acquisition of assets from a related party. So it didn't go into depth as to what listed securities were, doesn't go into depth around business real property. We've got a separate ruling that deals with that, but it basically goes through concepts such as what it means to intentionally acquire an asset from a related party, doesn't cover the issues around contribution rules. So when we're acquiring an asset, we're doing it via contribution, via purchase. We're not really covering off on that in 2010-1. We are dealing with that in tax ruling 2010-1. And of course, we've just had that updated and specifically updated around in specie contributions, which falls 100% under the remit of Section 66(1). So, and I'll come back to that in a moment, but we've got to make sure that when we are acquiring assets from a related party via a contribution, that not only are we meeting the requirements of 66(1), but we're also meeting the requirements of the arm's length and taxation issues as well. So we'll come back and touch on that. But that's not what this ruling deals with. And it also doesn't deal with the other SIS provisions, so the other investment restrictions that are linked within the SIS Act and the SIS regulations. And that's important because one of the things that I've always found is that, and being in the industry at the time that all these rulings came out, I actually think that that the work that the tax office did from a regulatory position in that period, sort of 2008 through to 2012, was pretty significant in the setting up of a lot of the core knowledge that we need within this industry to be able to operate. And all these rulings, I think, add huge value to any SMSF professional that is trying to operate in this space and trying to give advice to people. If they're not using these rulings as a reference piece to sort of not only broaden their own knowledge, but broaden trustees' knowledge in their space, then they're really not doing the job to the full extent. And so when we talk about things like acquiring assets from a related party, and when we say, well, let's reference SMSF ruling 2010-1, understand that is looking at Section 66 in isolation. It's not giving any consideration to Section 65 and financial accommodation. It's not giving any consideration to the sole purpose test. It's not even giving any consideration to the in-house asset rules, and that beyond the definition piece. And so we have to make sure when we're looking at 66, we don't look at it in isolation. And again, I'll come back and touch on that by using what is now becoming quite a well-known case around acquisition of assets from related parties and how it links in with the other SIS provisions. So this ruling was really only dealing with a few issues. Those issues were what it means to acquire an asset. And again, that acquisition piece is acquire through purchase or acquire through contribution, right? We then have more broadening of that, which comes down to the contribution ruling, TR 2010-1, which talks about what is a contribution, and we start to talk about the things like the improvement of an asset. So the improvement of a value of an asset is going to be a contribution. And so therefore we have to then look at it and go, well, how did that asset get improved and who did those improvements to determine whether or not there is an issue associated with related parties? And I'll come and touch on that in a moment as well. And then we talk about it talks about the acceptance of money by the trustees or investment managers. So the intentional acquisition of an asset from a related party, so whether it's the trustee that acquires the asset, so it's not about the final ownership piece there, whether the asset is acquired from a related party and whether the asset is intentionally acquired. So it covers off on all of those key issues, as I said. And for me, a lot of that comes down to the reality that for a self-managed superannuation fund, very hard to argue that an acquisition is not done intentionally if related parties are linked. But one of the key things about this ruling and this whole transaction piece, and it's certainly to me no more relevant than now as we have the finalisation a month or two ago of the non-arm's length expenditure rules, which also led to the finalisation of the TR 2010-1 contribution rules. And that is this concept around the performance of a service. And so what happened in that period? So this is all post 2007 super reform, and a lot of stuff came out there because the Income Tax Act was effectively rewritten and replaced from 1936 to 1997, and it adopted a whole heap of, well, it pretty much adopted all the previous measures, but it sort of refreshed it from a language piece, and so it raised lots of questions back in the time. Around all sorts of things that had a link to the SIS Act and superannuation, and so it then made us start to also review wordings and opportunities within the SIS Act and the SIS regulations and to how everything worked. And one of the issues that came up was performance of a service, because what we know is that trustees can't be remunerated, right? That's the definition of 17A, is that trustees can't be remunerated in their performance of duties as trustee. So then it came down to the concept of, well, okay, well, what if they're performing their duties, or what if they're performing duties outside of the scope of being trustee, i.e., they might be something like a related party builder. So if they are performing a service on behalf of their fund, right, is that service the acquisition of an asset, right? And this sort of was addressed through the ruling at the time. So basically the ATO's position was, where the trustee enters into a contract with a related party to perform a service, the performance of that service is the substance of the transaction, and not any rights that the SMSF might acquire or might also acquire to have that performed. So it came out that the acquisition of the performance is not the acquisition of the server, performance of the service, is not a contravention of Section 66. However, they then had to expand on it and said, but within that service, within that performance of that service, are there any materials provided? Because if there are materials provided, then those materials could form part of acquisition of asset from a related party. And so where we landed to was the regulator basically saying, if there is insignificant value as part of that service, then it's not an acquisition of an asset. And they gave the example of a plumber or a trustee who undertakes some plumbing work and replaces the washers in the bathroom, the kitchen, whatever it might be. That is insignificant, so that would not be an acquisition of an asset from a related party. However, they then went on to talk about somebody who installs air conditioners, and they said, well, that air conditioner is of significant value, right? And so therefore, if a air conditioner is installed and you effectively engage with yourself to do that because you run an air conditioning business and you supply the air conditioner, then ultimately that is an acquisition of an air conditioner from a related party, and that would be in breach of Section 66. And so this led down what was ultimately a couple of years debate, or not debate necessarily, but clarification being sought from the industry and the ATO about how to deal with related party builders and the provision of services that incorporated building. We saw the contribution ruling stating that if you'd made improvements to a property, that the value of the increase in the value of the property would be the value of the contribution. But now if we flip that on our head and say, well, now we've got further rules around non-arm's length expenditure, we can't do that work for free, right? So the super fund must acquire the material, the goods or materials, but we can't acquire it from a related party because it's not listed securities, it's not business real property, it's not in-house asset. So effectively, it led down this path of having effectively elements within the contract to say that the related party builder is acting as an agent of the super fund to be able to acquire those materials to utilize them in the improvements that are being undertaken by the property. So there's a whole heap of areas there that deal with this space, but then the expansion through to the gnarly rules that have been introduced since 2018 does cloud that again in regards to how we transact in that space. And I think we need to be careful with how we operate. So services ultimately are not acquisitions, but the substance of the service, what you're providing, can be an issue with regards to the acquisition piece. We then talk about money. and the ruling is quite specific that cash payments, EFTs, bank, personal check, money order, related party promissory notes are okay with regards to the acceptance of money. So they are assets that can be acquired, and it doesn't matter if it's Australian or foreign currency. However, then we turn that around and say, well, if we've got collectible banknotes or coins, trade dollars, barter credits, cryptocurrency, precious metals, they are not money for the purposes of acquiring assets. And if you acquire them from a related party, then that is going to be a breach of Section 66. So then the intentional piece is sort of rounded out throughout this whole transaction to say, okay, well, what is intentional when it comes from an acquisition point of view? And really, ultimately, what this does is just identify that the majority of SMSF transactions are going to be intentional. So the trustee knows of the relationship between the SMSF and the person or entity from whom the asset is acquired. The trustee has previous dealings with the person or entity from whom the asset is acquired, or the nature of the asset is such that it's likely to be acquired from a related party SMSF, e.g. shares in a closely held family company. So family or company. So the reality is, from an intentional point of view, Section 66, I almost sort of say to people when I'm providing that education piece here, forget intention, forget the word intention. Self-managed super funds are prohibited from acquiring assets from a related party because they always know that they're dealing with a related party. And so when you are dealing with a related party, just know these are the exceptions to the rules. These are the things that we can do. So as I said, a big piece of all this has been the expansion on the non-arm's length expenditure piece, and it's all linked also to the market value. So one of the key issues for Section 66, listed securities acquired at market value, business real property acquired at market value. Listed security, market value, really simple, okay? What's the value of the asset on the day of the transfer? It's there for us to determine. Business real property, what is the value of the property at the time of the transfer? You're going to need some form of valuation, preferably from a regulatory point of view. This is not a legislative requirement, but certainly from a regulatory way of operating, it's ideal if that is a third-party valuation, and it's got to be a justifiable valuation ultimately for determining that value. But if you're not doing that acquisition at market value, then you're in breach of Section 66. So that's a key issue to contemplate. If you don't do the transfer at market value, then you're in breach of Section 66. Now, what used to always happen as a result of 2010-1, talking about acquiring assets from a related party, and tax ruling 2010-1, which was the contribution ruling, was we always had this effective caveat where people said, okay, well, let's treat the difference between the purchase price and the market valuation as an in-specie contribution. And from a tax point of view, that was effectively the accepted process in that regard. And so often people would, if the appropriate amount of cash wasn't paid, they would treat the difference as a contribution. Ultimately, what's happened now since the NALI rules have been updated and the legislation's changed is the tax office have clarified their position here to say, well, the reality is that it comes down to the terms of the contract. And if the contract says this is the purchase price and that purchase price doesn't represent the market valuation, and you then try to capture the rest of it as an in-specie contribution, then that valuation difference is going to be a non-arm's length expense, right? And you're going to tarnish the asset as a non-arm's length income producing asset. So that's problematic. However, from a contract point of view, there's nothing to suggest that you can't, in the initial contract and the documentation supporting that, state that this asset is going to be acquired part purchase and part contribution, and the market value is X, and the purchase amount is going to be Y, and the contribution is going to be Z. Okay, so having those amounts distinguishable is acceptable. So you can still do part purchase, part contribution. You've just got to make sure that that is known from a documentation point up front, rather than a way of rectifying and fixing it at the post the event. So getting that market valuation piece is pretty critical in regards to how we operate. So From a related party point of view, I'll touch on, as I said before, there's a case that I'll talk about, which most of you would have heard about before, but I wanted to, and you look at that slide before and go, well, what's FAAQ versus just FAQ? Well, it's a frequently asked acquisition question, and probably the most frequently asked acquisition question that I've had over my various tenures, whatever the word is there, at various admin firms and that as well, including my time at SuperGuardian, was whether or not an SMSF can acquire assets via an employee share scheme. And this is an area that the tax office have partly addressed at different stages in time, but it's always a problem, and primarily it's a problem that is created because a lot of times trustees don't ask the question, they undertake the transaction first, and then it is incorporated from an administrative point of view and a processing point, and then it comes to audit. All right, and when it gets to audit, you're at that first stage, ultimately that first stage of compliance eyes, right, that the ATO are relying on to make sure that everything is being undertaken correctly. And so the question is, probably not can I acquire assets via an employee share scheme, but the question often really should be is, I've acquired these assets, I got it through an employee share scheme, was I able to do that, right? And the reality is that this is one of those typical superannuation scenarios of it being a it depends kind of answer, because there are ultimately two types of employee share schemes that are in existence within our industry that we see from a common point of view. And then there are those that are effectively performance/remuneration-based employee share schemes, right? And so this is where, and you'll often see this with startup businesses or whatever, but it's a situation where, based on your performance or based on the position, you are issued with shares in the company, right? And those shares are issued to you personally, as the employee. And often they might be issued with all sorts of rules, and those rules might say things like, and you can hold them in any entity you choose, blah, 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 right? That it might go that far. Can the self-managed super fund be one of those entities, is the question that we often get asked. The short answer is no, right? Because more often than not, that company is not a listed company, right? So, and definitely that company is not business real property, right? And most likely that company is not an in-house asset. Right? So does it meet the definition of a listed company? If it does, so if it is a listed company and you've been given shares through an employee share scheme, then under the acquisition of an asset from a related party rule, it's possible that you can do it. Right? But then again, are you doing it at market value? Is there some form of discount involved with it? If there's a discount involved with it, does that create a non-arm's length income issue? There's a lot of problems around employee share schemes in that environment. You then have, and that is because the entitlement is the individuals as an employee. You then have employee share offers, right? Employee share offers are quite different to employee share schemes, right? And they are not remuneration based, but they are employment based, right? So they are linked to your employment, right? And as an employee or a contractor or whatever it is of the company that is offering shares, you are entitled to receive an employee share offer, right? And with those offer comes a whole lot of terms and conditions around the investment that you can apply to acquire. Now, if you're applying to acquire it, what it ultimately is suggesting is that the ownership currently exists or sits with an unrelated body. Now, of course, you've got to go through that test and determine whether or not there is a link from a related party point of view to start with. But if under this offer, one, the shares are currently owned by an unrelated party, and you are going into the offer like everybody else is going into that offer to be able to put an application in and ask CAT for a certain number of shares and then get an allocation from the company, then that employee share offer is acceptable, right, from a transactional point of view, so long as you meet all the other rules around, that it's not related party, right? So that's why the first question's got to be, who are we acquiring the shares from? So if the shares are effectively gifted to you through your remuneration or whatever, then you can have problems, right? But if you don't have any ownership and you don't actually have any say as to whether or not those shares will be allocated, it's application based for determination by a separate party, then ultimately that opportunity can be provided for in the SMSF space. For me, it's one, and I've done it before, where I think there's value in asking the question of the reg guide. You can apply for a SMSF specific advice. I've done that with employee share offers before and got a positive result. So I think it's one of those areas that there is certainly value that can be added by dealing in that space through through the ATO system. The case that I wanted to speak about, sort of, and to help wrap up today's session, is Merchant and the Commissioner of Tax, because this is a case that I've certainly spoken about in these webinars before, but it's really relevant because on face value, what Mr. Merchant, what Gordon Merchant has done here is he's acquired listed securities, right? And what's he acquired? He's acquired Billabong. Right? Now, my self-managed super fund many years ago had Billabong shares as well. But then we realized that those Billabong shares were worth less than the board shorts that I had purchased from Billabong. So, the shares lacked any real value or substance, and certainly no future benefit for my self-managed superannuation fund. And indeed, they didn't provide any future value for the Gordon Merchant superannuation fund. So here we had a situation where Gordon Merchant received advice that under SIS Act, his superannuation fund could acquire those Billabong shares from the Merchant Family Trust, right? Who are you acquiring them from? Merchant Family Trust. Is that a related trust? Yes, it is, right? Yes, it is. We have to go and look at our prohibitions, right? We can't intentionally acquire an asset from a related party unless it's a listed security, business real property, or an in-house asset. Billabong was a listed security, so there was no issue with the acquisition purely under Section 66. The family trust also held shares in this other company called Plantic, right? And that Plantic had an opportunity to be sold and to make a significant gain for the Merchant Family Trust, right? So we're talking like in the millions, $80-odd million worth of gains there. From a loss point of view, the Billabong shares created a significant capital loss. And so the transfer of those shares to the super fund provided a positive tax position for the family trust, which of course provided a positive tax position for Mr. Merchant. And what it ultimately provided was a super fund with shares that ultimately had very little value attached to them versus what they previously were. So under purely Section 66, this transaction's okay. However, it's why I started this presentation with the sole purpose test. Why did the super fund acquire Billabong? Was it to provide retirement benefits for the for Mr. Merchant and services, or was it to provide some other benefit to financial detriment potentially of the self-managed superannuation fund, right? And in this instance, he was breached and was found to contravene not only the sole purpose test, right? So the operating standards, but the sole purpose test, because the nature of the transaction wasn't to provide retirement benefits to the member, it's to provide a tax benefit to the family trust, right? And also financial assistance to the members or relatives, which is indirect, right? The indirect financial assistance is he pays less tax, right? So he pays less tax because of the trust distribution and everything else. And so therefore he benefits out of this transaction that the super fund entered into. So this is the piece where I highlighted before that SMSF ruling 2010-1 just looks at the acquisition, not at all the other provisions. And just because you can do something legally doesn't mean you can do it more holistically from a super fund point of view. And that was ultimately the position. He was disqualified as trustee, but then he won his appeal to have that disqualification overturned because it was a one-off transaction. And in that one-off transaction, he had received professional advice to say that was okay. So they felt that he was not at all a risk to the public. with regards to the operation of that fund. He had to appoint a second trustee, because he had a corporate trustee. He had to appoint a second director to act as trustee with him, but he was able to continue on as a fund. So when we look at the penalty regime, to broadly finish this off, when we look at the penalty regime, you've got your civil and criminal penalties that are incorporated around some of the issues that can result from the breach of Section 66, sole purpose test, financial assistance, borrowing rules, extended in-house asset rules, versus Section 66, which is neither an admin penalty provision, so there's no SMSF admin penalty for it. It is effectively an imprisonment situation, which is why you don't see, you very rarely see any penalties coming out around acquisition of assets from related parties, but more so around a whole heap of other regulatory provisions. So to bring this to a closure, I come back to the question that I've highlighted at least twice. Right, when making decisions inside a fund, the first question you always ask, and there's three questions. The first question is, who are the parties to the transaction? Right? If it's not related, no more questions. Then you just go about your transaction as long as it's undertaken on market value. If it's a related party, then the next question is it an exception to the prohibition? Listed securities, business real property, in-house asset, right? Family law. If it's an exception, right, then we look at the valuation. Market value for listed securities, market value for business real property, market value and less than 5% total in-house assets for the in-house asset acquisition rules. And of course also, or not 5% if you've got your 1322C exceptions in that as well. So look, that's a bit of a summary of our acquiring assets from a related party rules in Section 66. Next month, we are going to look at trust investments inside of self-managed super funds, which really rounds out this 3-month period of presentations for myself in a way of highlighting the key issues around the various trusts. So related trust versus unrelated trust versus LRBA trust, all those sorts of elements associated with it. So I look forward to you joining me in December for that. Between now and then, enjoy your November and whatever else you're doing for the rest of the year as we start to wind down the year. Thank you for attending today, and I look forward to catching up with you all in December. So thank you, and unless there's any questions, I will see you all next month.